प्रतिष्ठित एवं चर्चित कोचिंग संचालन होने के चलते हमारे पास मुगल एवं गौतमी पटिशनर मेंबरशिप नामक 2 व्यक्ति आए और करीब जून माह में और बोला कि सर यदि आपके पास कुछ बेरोजगार लड़के हैं तो मैं अपने बॉस से मिलवाता हूँ, तो MES में करवा देंगे। उस वक्त कुछ लड़के हमारे पास बैठे थे तो वे लोग सुने तो बोलने लगे कि हम लोग को भी करवा दीजिए सर। मैं सोचा कि ठीक ही कह रहे हैं, हमारे कोचिंग का भी नाम हो जाएगा और तुम लोग भी सेटल हो जाओगे। उसी माह में अरवल में सहारपुर के पास संजीव उस से गाड़ी में ही बातचीत हुई, क्योंकि उन लोग बोला कि बॉस गाड़ी से नहीं उतरेंगे। वहीं पर पप्पू का मकान है जिसमें अभी स्वामी विवेकानंद स्कूल चल रहा है। उनसे अपना ID भी दिया तो हमें विश्वास हुआ और हुजूर ये पैसा देते हैं। पारा नंबर 4 में हुजूर है 25,000 रुपये के हिसाब से 20 बच्चे को पप्पू कुमार के कहने पर रोहित कुमार को देते हैं 5 लाख रुपया। फिर हुजूर आते हैं पारा नंबर 5 में 15 लाख रुपया ये देते हैं। मुगल के साथ एक और लड़का राजेश आया, मैं उसे पैसा दे दिया। उसके बाद में हुजूर ATM देते हैं पप्पू को। फिर उसके बाद में हुजूर पारा नंबर 10 में हुजूर 12 लाख रुपया पप्पू को देते हैं। पारा नंबर 11 में 25 लाख रुपया ही पप्पू को देते हैं। लास्ट में हुजूर मेरा नाम आता है पारा नंबर 14 में।
Yes, you have. If your argument is that you have not accepted the money and money has been given to Mughal and another and Rajesh, still we are not inclined to grant you.
No role, my lord.
That's all right. We will now specify the role played by you. You want that, or you just want to withdraw for surrendering?
My lord, sir.
All right. We dictate the order. After the order is dictated, if you find that that order would chase you till your regular bail, you can ask the court. The court will allow you to withdraw.
My lord, sir.
It's something which is absolutely uncondonable. You have taken part in the entire transaction. You, along with others, the FIR may not have been written in that way, but I can read many more things in the FIR which is not evident to you because you are holding his brief. All right, heard Mr. Bulli. Heard Mr. Nityanand Neeraj, learned advocate.
One thing, my lord, sir. ये हुजूर पारा 16 में खुद कहते हैं हुजूर कि मेरे
Even if let me tell you,
पप्पू मुगल हमारे
वो देख लिया है। पप्पू मुगल दूसरी बार जब पैसे देने गए तो मुगल और कोई दूसरा, बाद में मुगल और राजेश, और लास्ट में जब पैसे मांगने वापस गया तो आपने बंदूक दिखाया कि भाग जाओ, मैं तो पैसे
उसमें सिर्फ लिखे हुए हैं।
But in any view of the matter, I am not granting. Even if you are remotely associated, I am not granting anticipatory bail.
सिर्फ इतने हैं, लिखते हैं कि 4 लड़के खड़े थे।
I couldn't have been more specific than this, and I couldn't have been more transparent than this.
My lordship, due to village politics, my lordship,
Sorry,
informant also made accused, my lordship. Informant is also made accused.
He should be made accused. He is a coaching owner. Yeah, if he were not made, just a minute, if he were not made an accused, while dictating the order, we would have instructed the investigating agency to frame you in this case. I mean the informant in this case. वो नहीं है, anticipatory bail नहीं देंगे. It's a waste of time.
हमारा
argument.
कोई रोल नहीं है हुजूर, 420 का तो केस बनता नहीं है। मेरे ऊपर सिर्फ है कि हम साथे हैं, हम मांगे भी नहीं हुजूर, मुगल के साथे सिर्फ।
All right, now. Let me That's all right. We will say we will record your arguments. But I'm not inclined, not at all, even in the least.
420 का 2000 हमारे ऊपर बनता है, मेन बनता है मुगल के ऊपर।
मैं बताता हूँ किस चीज को बनता है। We will dictate it in the order. Like, heard Mr. Nityanand Neeraj, learned advocate for the petitioner and sons of the state. The petitioner seeks bail in anticipation of his arrest in connection with Jahanabad PS case number 83 of 2020, dated 7/2020, instituted for the offences under section so-and-so. Stop. a coaching class owner is said to have been approached by the petitioner and one Mughal to impress upon him that in case money is transacted, the students taking coaching classes could be accommodated in military engineering service. The aforesaid two persons, which included the petitioner also, projected that if the answer of the informant was in the affirmative, he would introduce the concerned students and the informant to his senior officer. Several lakhs were collected and given to one Mughal and Rajesh.
Sanjeev Urko.
Mughal and one Sanjeev alias Pappu. The informant and the aspirants harbored some hope of getting employed, as they were also sent for medical checkup before the employment letter could be given to them. However, later it was found that it was all fictitious. When the informant went to take back his money, as none of the aspirants could be provided with job, it is alleged that the petitioner, who was one of the occupants in a car, brandished his weapon and even refused to recognize the informant. Land Counsel for the petitioner has submitted that the only allegation against the petitioner is that he, along with one Mughal, had first approached the informant for giving employment to the students taking coaching classes in the coaching school of the informant. Thereafter, the petitioner was not to be found or spoken of when the money per head was given to Mughal and Sanjeev. Later also, the name of the petitioner does not transpire in any transaction whatsoever. Only in the last part of the accusation, has it been stated that the petitioner threatened the informant and others of not agitating about return of the money. Land Counsel for the petitioner has submitted that thus, even if the accusation is accepted to be true, the offences under sections 4 and 6, 420, 467, 468 and 471 of the IPC cannot be said to have been made out against him. He further submits that the informant of this case has also been made an accused in this case, as he had been bungling in the matter. Lastly, it has been submitted that because of village rivalry, the petitioner has been made accused in this case. After having gone through the first information report, where the petitioner has been named as one of the two persons who had impressed upon the informant to provide job to the aspirants taking coaching classes, and later the allegation being of threatening the informant and others of not demanding their money back, I am not inclined to grant anticipatory bail to him, notwithstanding the fact that the petitioner is not shown to have been present when the money exchanged hands. The petition is rejected. However, if the petitioner surrenders before the court below and seeks bail, his application shall be considered on its own merits without being prejudiced with the fact that the present petition on his behalf has not been entertained. I have been least abrasive. This is the softest order that I could have passed. In fact, I wanted to be rather harsh. Next.